Hello students, welcome to this class, and in this class we are going to look at chapter number 3, which is about custom as a source of law in international law. So the purpose for this chapter is for you to understand how consistent and accepted practices among states become legally binding rules in international law even without written agreements. So these are the objectives for this chapter. So previously we looked at treaties as a source of international law in the second chapter. So here we are going to look at custom as the second source of international law as listed in Article 38, Paragraph 1 of the Statute of the International Court of Justice, and it is international custom as evidence of general practice accepted as law. So it is also placed on the same footing as international conventions as a primary source of international law. So a custom generally refers to an established pattern of behavior that can be objectively verified within a particular social setting. For example, what has always been done and accepted by law. So a custom may lead to prescription which are rate enjoyed through long custom rather than positive law. So Yale briefly describes it as follows. So it says that custom in its legal sense means something more than mere habit or usage. So it is the usage felt by those who follow it to be an obligatory one. So there must be present a feeling that if the usage is departed from, some form of sanction probably or at any rate ought to or fall on the transgressor. So customary international law results from a general and consistent practice of states followed by them from a sense of legal obligation. So international custom is described by Hans Kelsen as unconscious and an international lawmaking. So let us have a look at evidence of international custom. So the principle of customary law outdates international law. Is difficult to define, and yet it is a crucial philosophic basis of the entire edifice of international law. So the primary evidence of customary law is found in actual practice of states, and idea of this can be gathered from published materials such as newspaper reports of actions taken by states or statements made by government spokesmen to parliament, press, and also at international conferences and at meetings of international organizations, and also from the state's law and judicial decisions because legislature and judiciary form part of a state just as the executive does. So in other words, Martin also reached that the determination of customary international law is more an art than a scientific method, and this is because uh, determination of international custom involves many pertinent questions, and there is no cut and dried formula laid down by international law as such for arriving at an international custom. So in such situation, the judgment of international court plays a crucial role in establishing international custom. So let us look at state practice through the objective element of international custom. So the scholars have classified the requirements in what is referred to as two-element theory, by which for a custom rule to arise, two elements must be present. So on one hand, there must be a significant state practice, and on the other hand, the practice must follow from opinio juris, that is the belief that such practice reflects international law. So, firstly, let us deal with the objective or material element of customary international law, and that is state practice, which is also referred to as constant and uniform usage in the asylum case. So, while assessing state practice, two distinct matters need to be addressed, and these are the selection of practice that contributing to creation of customary international law, and the assessment of whether this practice establishes a rule of customary international law. So it is also widely accepted that the reiterated conduct of states fulfills the objective element for the formation of customary norms, and also the practice of the executive, legislative, and judicial organs of the state can contribute to the formation of customary international law. So let us look at customary international law. So according to the rate of passage case, that was Portugal and India in 1960, there are two types of custom, and that is general and local or regional. So in general custom, customary rules binding upon international community as a whole, but in local or regional, it is applicable to a group of states or just two states in the relations. So custom is the oldest and the original source of international law as well as law in general. So when a usage receives the general acceptance or recognition by the states in their mutual relations, it is understood that such habit or usage has become right as well as obligation of the states, and it becomes a custom. But however, uh, although a custom is widely followed, it does not make it a rule of international law, and unless it is accepted by the states as legally binding in order to be considered rules of international law, are also referred to as opinio juris. So let us have an example of essential elements. So we have practice and opinio juris, and here we're going to have a look at some of the examples of these cases. So the first one is in advisory opinion on the use of nuclear weapons, and that was in 1996. So it was held that no rule can be created on opinion juris without state practice. Also, in the SS Lotus case of Turkish International Water, PCIJ, Series A, number 10, in 1927, it was also held that a new rule of customary international law cannot be created unless both elements, as discussed, are present. Also, it was also reported in North Continental Shelf case, that is ACJ uh, report that was in 1969, and that was at page 3 and page 44. And it was held that not only must the acts concerned be a settled practice, but they must also be such or be carried out in such a way as to be evidence of belief that this practice is rendered obligatory by the existence of rule requiring it, and also the states concerned must feel they are conforming to what amounts to a legal obligation. So there are very many cases that were rose, but these are just a few examples of them. So also this included in South Africa, Colombia, Peru, and many other states. So I have attached the reading material for this chapter. In case you want to read more, please use these materials. That's all for now. Thank you.